Honour then turns to paragraph 13 of the document. By our count, there are no fewer than 12 grounds of judicial review in respect of that decision identified in paragraph 5, which Your Honour will find at paragraphs 14 through to 24. But then, somewhat at odds with paragraph 5, in paragraph 13, an attack is mounted in respect of an anterior decision, the provisional determination made under a different provision in the Therapeutic Goods Act. So it's not entirely clear to us at the moment, Your Honour, whether there's only one decision with respect to children that's being challenged, or whether, as might be thought to be suggested by paragraph 13, there are two decisions in play. That may well inform, well, it probably will inform the evidence that we adduce, and may well inform whether any application for non-publication or suppression orders on the basis of confidentiality need to be made by my client in due course.
Well, I'm starting to tend to the view that once I've finished indicating the way in which I think the matter might proceed, that what we should be doing is having the concise statements and the notice of objections for competency filed, and then bring the matter back forthwith for case management. I can indicate, in my view, I'm still happy to set a tentative couple of dates, which would fit with the timetable the parties have prepared, and block those out in my diary, and ask counsel to do likewise, so that you don't feel, Mr. Robinson, that you've been prejudiced with respect to obtaining a trial date. But I feel loath to start trying to set a comprehensive timetable when there's clearly a need for greater clarity between the parties as to what the issues are, and clearly even a challenge to the question of whether or not reasons have been given for one of the decisions that you attack on a very substantial number of grounds.
Your Honour, we didn't appreciate that we'd tied the Commonwealth up in knots in the way my friend has indicated. It may be that when we do our concise statement, we seek leave to refine the pleadings, the originating application, and make it concordant with the precise statement,
yes,
and put the Commonwealth out of its misery.
I think that sounds, I'm not sure the Commonwealth is miserable, but I think that it might be, that further reinforces the point that I've just made, and I think is a very sensible proposal, Mr. Robinson, with respect. So just so the party can think about where I was going to with the other matters, I also felt that there was a need to allow in the timetable, perhaps at the same time that submissions are exchanged, for notice to be given of any objections to evidence, with the opportunity then in the submissions in response to respond to and address those objections, and that would be on top of the page length I've allowed for the written submissions themselves.
Yes.
So I wouldn't, and I would expect that only valid real objections to evidence would be taken. Not suggesting only those I'd uphold, because no one will know that till they're argued, but that there'd be sensible forensic decisions made about what is and isn't objected to, is my point. Then also that I'd prefer to have the bundle of authorities in electronic form. That's the joint bundle, which will save the parties a lot of photocopying and assembling of folders. But that it be properly bookmarked, including with the requisite pinpoint citations, which recently someone did in a case I did and I thought was extremely helpful. So they were the main things at this stage that I had in mind. The other issue to consider is a court book, electronic court book. which would also be properly bookmarked. Again, can save on a lot of paper and mean that everybody can find things a lot more quickly.
Yeah.
So I won't make all of those timetabling orders until now we reconvene for the next case management hearing. But if we now have a look at possible tentative trial dates for one or both of the claims, we were looking. You came out around about in April, I think.
Yes, Your Honour. I think the last step in our proposed orders is that which is contained in paragraph 7, written submissions in reply by the 8th of April.
Sorry, I'm just looking at the number of trials and things I have coming up in April and May. Because there's no point in listing something when you know you can't get a judgment out. All it does is move the expectation from you onto me. People's.
What about the 30th of March, Your Honour? We can adjust the timetable.
No, that's not convenient, I'm afraid. Then I have a trial the following week, and then the following week I have a trial, and then we have Easter. We could list on tentatively on the 19th and 20th of April.
Yes, that would be suitable.
Is that possible for you, Mr. Kaplan?
Your Honour, the 20th is, but not the 19th. I have another hearing on the 19th.
I'm on leave on the 21st.
Like, kids might die. They fucking.
And then
serious?
I have a trial starting as soon as I come back. Well, we'll definitely grab the 20th.
Yes, thank you, Your Honour.
And it's possible one of my matters, which has gone off to mediation, might resolve. So why don't we talk about another day, given that it looks like we'll be hearing the matter sequentially anyway when we hold the next case management hearing. And if that matter is vacated, that would open up space in my diary, which would be, and it was a 4-day hearing. It would be a bit earlier in April, around well, that matter's listed in my 7, 8, 11 and 12.
When she said those dates, he went.
Your Honour, that may be difficult for me, although it's difficult to say at this stage on account of the High Court sittings. I have a matter that is very likely to be listed in that period, but
well, we'll just have to set a date, Mr. Kaplan, and ultimately, if the applicant's counsel are available,
11 and 12 are fine for us.
All right. Well, what I'll do is I'll make a note in my diary that you're available then in the event that matter is successfully mediated. Then I think we'll set it down for one or both of those dates, or alternatively, we have the other date for at least one aspect of the claim. But we'll settle on those trial dates at the next case management hearing. It may be at that stage, Mr. Kaplan, that you also have greater clarity on your commitment in the High Court.
Thank you, Your Honour.
Are you content with that, Mr. Robinson?
Yes, Your Honour.
Now, all of that is going to be dependent on the matter being ready for trial, and I'm not formally listing it on those dates because at the moment, clearly it isn't.
We're ready for trial now, Your Honour.
Well, you're not, Mr. Robinson, with the greatest of respect. You've indicated that you may well you thought you had reasons for decision which you now don't have, and you're looking at amending your originating application. So I think let's just be realistic.
We're ready tomorrow, Your Honour.
Yes, the respondents are not ready. I have no idea of their case, and they have no evidence on yet. So the case is not ready for trial yet. So I'll set it down, all going well, when we have the next case management hearing. So let's have a look at the dates for that. I want that very soon after we have filing of the concise statements. So we've got that being filed on the 1st of March from the respondent. I've got 3 case managements on the 3rd already and a full court appeal on the 2nd. But look, I could do a case management hearing on the 3rd in the afternoon. And I could do that after court.
That's the 3rd of March for case management is fine for us.
Thank you.
Your Honour, it's fine for me as well. Could I, however, take up Your Honour's offer to have the matter listed after court? I'm in the full court on that day.
Right.
But won't be in court, say, from about 4 p.m. onwards.
All right. So we'll list, if you're confident 4 p.m. is the time, then we'll list it for 4:15, or would you prefer 4:30 to be safe, Mr. Kaplan?
I'm in Your Honour's hands. Either time would be convenient.
Well, I think 4:15 would be better then in that case. Mr. Robinson, is that convenient to you?
It is, Your Honour.
Because we may have a fair bit to discuss at that point. And in the meantime, it may well be that draft orders might be prepared for in advance, which would reflect the matters that I've raised in the course of this hearing as well. But I do feel it's really important that we do, and for clarity's case and my own sanity, that we have very clear division between the 2 very different claims in the submissions and in the evidence. I think so. I'm expecting separate concise statements from the parties with respect to each of the 2 aspects of the claim, of the proceedings. Thank you, Mr. Robinson. All right, so I'll make an order also that costs be reserved and that there be liberty to apply on 3 days written notice. Is there any other order that needs to be made today aside from an order setting the matter down for case management at 4:15 on Thursday, 3 March 2022?
Nothing from here, Your Honour.
Thank you, Mr. Robinson.
Mr.
Kaplan?
All
right. Well, may I thank you both very much for your attendance and for your patience with all of the issues that I've thrown at you both and dealing with them both so appropriately. The court will now be adjourned.
This court is now adjourned.
What the actual fuck?